Hello, my dear students. Today we are going to discuss about the concept of reference as provided under the Code of Civil Procedure 1908. This topic is mentioned in unit number 4 of the university syllabus, but we have already discussed in my previous lecture the topic on appeals and also discussed about appeal from original decree and appeal from appellate decree and general provisions as to appeal. And this is the topic which we are going to discuss today in the unit number 4. As far as this word or the expression reference is concerned, the said word has not been defined in the Code of Civil Procedure. My dear students, as you all are aware that Section 2 of the Code of Civil Procedure has defined various expressions but the legislature did not or failed to provide this definition of reference therein. But only provides or gives a relevant provision for the understanding of this concept of reference. And the relevant provision for reference is given under Section 113 of the Code of Civil Procedure and Order 46 of the CPC. Wherein Section 113 of the CPC deals with the substantive portion and Order 46 of the Code of Civil Procedure provides the procedural portion. As far as Section 113 of the CPC or the Code of Civil Procedure is concerned, it empowers a subordinate court to state a case and refer the same for the opinion of the High Court. Such an opinion can be sought when the court itself feels some doubt about a question of law. Here, the word court, wherever it occurs in the court, means a court of civil judicature, meaning thereby the reference can only be made by a court and not by persona designata. Means a tribunal cannot be said to be a court within the meaning of this code. A reference can only be made by a court when there is reasonable doubt about a question of law, or only when it is of opinion that the act is ultra vires. My dear students, as you all are aware that this particular aspect differentiates the other subtopics mentioned in unit number 4 with this topic. The other topics which have been given under the Code of or the unit number 4 of the syllabus pertains to appeals, reference, review, and revision. As far as the appeals are concerned, or the other, apart from revision, apart from reference is concerned, in those, the same can be filed by the party to the court of law, whether it's an appellate court, higher court, or the high court, or before the same court. But here, the reference is made by the lower court itself. The role of the party or the filing of an application by the party is not exist in the case of reference. In reference, the lower court judge, if it feels that the question of law involves where there is a reasonable doubt about the question of law, and when it is of the opinion that the act is ultra virus, then that particular lower court judge may refer the matter to the high court to give appropriate directions in that particular case. Now, I would like to apprise you about the object of reference. As far as the object for reference is concerned, the object for the provision of reference is to enable subordinate courts to obtain in non-appealable cases the opinion of the High Court in the absence of the question of law, and thereby avoid the commission of an error which could be remedied later on. So this is the object of the revision, meaning thereby this reference can only be invoked by the lower court where there is no appeal, or where there can no appeal lies with the party or to the or in this suit itself. Now, I would like to give you the grounds or the conditions for making a reference before the High Court. When all the following conditions are satisfied, the court is bound to make reference to the High Court under this proviso, under setting out its opinion and release for it. Number one, a question as to the validity of any act or ordinance or regulation or any provision therein arises in a case before the court. Second is, the court is of the opinion that the same is invalid or inoperative, and the same has not been till date been declared invalid by the High Court, to which the court is subordinate, or by the Supreme Court, and the determination of the validity thereof is necessary for the disposal of the case. No reference is warranted under section 113 of the code where nothing involved regarding the issue of any act, ordinance, or regulation. The right of reference, however, is subject to the conditions prescribed by the Order number 46, Rule 1, and unless they are fulfilled, the High Court cannot entertain a reference from a subordinate court. The rule requires the following conditions to be satisfied to enable a subordinate court to make a reference. Number one, there must be a pending suit or appeal in which the decree is not subject to appeal, or pending proceedings in the execution of such decree. Second, a question of law or usage having the force of law must arise in the course of such suit, appeal, or proceedings, and the court trying a suit or appeal or executing the decree must entertain doubt on such question. What do you mean by reasonable doubt? A reference can be made on a question of law when the judge trying the case entertains a reasonable doubt to make reference. So from this, my dear students, we may infer that reference can only be made with regard to question of law, which and which makes the judge trying the case entertains a reasonable doubt in his mind. Only then this reference can be invoked. Now, who may apply? Only a court can refer a case either on an application of the party or suo motu. So from this, my dear students, we may differ this reference from the other remedies such as appeal, review, and revision. Further, a tribunal or persona designated cannot be said to be a court, and as such, they do not have this power to make reference to the High Court. Now, what are the powers and duties of the referring court? A reference can be made only in a suit, appeal, or execution proceedings pending before the court. Such reference can be made when a subordinate court entertains a doubt on a question of law. And third, such question must have actually arisen between the parties, and the court must have been called upon to adjudicate the list or the litigation as the case may be. Now, what are the duty of power and duties of the High Court? Number one, the jurisdiction of the High Court is consultative. Second, power of the High Court is not confined to the questions referred by a subordinate court. And third, if a new aspect of law arises, the High Court can consider it. So these are the powers and duties of the High Court while entertaining a reference forwarded to it by the lower court. Now, what is the procedure at hearing while adjudicating a reference? Number one, statement of the facts of the case needs to be mentioned. Second, formulate a question of law and on which the opinion is sought, and High Court can give its opinion. Now, what is the duty of the reference court when they have already invoked the reference jurisdiction of the High Court? Till the pendency of the reference, the court, the referring court may stay the proceeding or pass a decree or order contingent or conditional upon the decision of the High Court. Now, whether any cost can also be imposed by the High Court. As a general rule, the cost of reference shall be the cost in the cause. But if the reference is altogether unwarranted, the High Court may direct the referring judge to personally pay the cost. Meaning thereby, my dear students, if the High Court feels that the same has been wrongly or illegally used by the reference power used by the trial court, then in that case, High Court may impose the cost on the judge on the judge concerned. Now, what is the remedy in case the reference is dismissed or refused? An order refusing to make reference to the High Court is a case decided under section 115 of the code, and it is revisable, meaning thereby a revision may lie. So my dear students, this is all about today's topic. Hope you have learned a lot out of it. In case you have any query, then you may write it to me at my email ID, that is rahularora.gn@jagannath.org. But before parting with today's lecture, I just want to apprise you with my new topic, which I am going to take in my next lecture. And my next lecture would be on review, and the relevant sections for the same are given under section 114 of the Code of Civil Procedure and order number 47 of the CPC. As regards section 114 of the CPC is concerned, it provides the substantive portion on the law, and with regard to order 47 is concerned, the same provides the procedural portion on the law of review. I hereby direct you to kindly go through the set provisions which would make you or help you more in understandable with regard to said topic in my next lecture. Thank you very much. We'll meet you soon in my next lecture. Till then, stay home, stay safe, and stay healthy. Thank you very much again.